Hello, everyone. Welcome to the Siam Center Law Group podcast, a space where we share important legal knowledge in an easy-to-understand way so you can apply it in real-life situations. Today, we'll be discussing the steps of defending a criminal case. What should lawyers do to help defendants avoid jail? In the real world, the chance of someone avoiding a criminal case doesn't just depend on their innocence or luck. It requires strategic planning, a systematic approach, and a deep understanding of the justice process. Everything starts right from the investigation stage. When you are called in for questioning, the most crucial decision is whether to plead guilty or deny the charges. Denying without a clear direction or giving vague statements might not help, and sometimes it could even harm your case in court. This is where the lawyer's role in the investigation is vital. The lawyer will guide the defendant on how to give a testimony strategically, prepare necessary documents and evidence, and, if needed, request further witnesses to ensure all information is gathered from the beginning. Starting well at the investigation stage is like laying the foundation of a building. If this step is mishandled, the chances of successfully defending the case in court are significantly reduced. Then once the case is handed to the prosecutor, if there are key pieces of evidence that the police didn't collect, the lawyer can request fairness and ask the prosecutor to consider bringing those witnesses in for additional investigation. This is often the final opportunity before the case is filed in court, so thorough work at this stage is extremely important. If the case does go to court, the lawyer must lay out a clear defense strategy. This includes making an opening statement, clarifying the defendant's side of the story, and planning cross-examinations of the prosecution's witnesses to undermine their credibility and highlight any inconsistencies that could show the case's flaws. The lawyer also has a critical role in bringing in defense witnesses, such as those who can confirm the defendant wasn't present at the scene, or evidence that proves the defendant was not involved in the crime. Additionally, if new evidence or witnesses come to light during the trial, the lawyer can request to call in those witnesses to ensure no important facts are missed by the court. Finally, after the witnesses are examined, the lawyer will deliver a closing argument to summarize everything and point out to the court that the evidence doesn't prove the defendant's guilt or that there's reasonable doubt. According to criminal law, if there is doubt, the benefit of the doubt must go to the defendant. As you can see, each stage is interconnected, from the investigation through to the closing argument. From our experience, there are two key stages that matter most: preparing for the investigation and witness examination in court. If you plan and prepare well during these two phases, your chances of winning the case, or at least reducing the sentence, are much higher. Remember, don't wait until the court case to find a lawyer. Get one from the start. It's easier to fix things early than to try fixing them when it's too late. Today, Siam Center Law Group hopes this podcast helps you understand the criminal case defense process more clearly. If you or someone you know is facing a criminal case, don't hesitate to contact us for a consultation. We're ready to provide you with close support. See you in the next episode. Don't forget to follow the Siam Center Law Group podcast so you won't miss valuable, easy to understand legal knowledge you can actually apply. Goodbye.